Good afternoon, Section Z. We are ready for the last lecture in Chapter 11 of the dukeminier text on zoning. The topic we're taking up now is exclusionary zoning. And so imagine that you are a city council member, you are in a developing town on the outskirts of a major metropolitan area. In your state, the cost of municipal services is financed in large part by property taxes on real estate. So that includes public schools, which tend to be a big ticket item, but you also have to rely on property taxes for things like fire service, police service, that kind of thing. And you campaigned for and won your seat on the city council by arguing that the city needed to take steps to reduce local property taxes. Taxes were just too high. So now you're in office and it's time to deliver on that promise. And so you are drafting a proposed zoning ordinance that's intended to steer municipal development in ways that will further your agenda of reducing taxes on taxpayers. You're going to try and increase revenues and decrease expenditures, but in a way that reduces the tax burden on voters. So what are you going to do? What are some of the kinds of uses that you're going to encourage, and what kinds might you discourage? Well, first of all, you might think of industrial zoned areas as particularly advantageous. And so you might set aside large parts of your municipality for industrial uses. Industrial users tend to pay high taxes. They tend to consume fewer municipal services than other users of property in the jurisdiction might. But they may have employees who vote, but the industry itself doesn't have a vote. And so that might be helpful to you if you can collect higher taxes from them and then reduce the tax burden on the voting public. And it's okay if some of the land that you zone for industrial use remains undeveloped, because they still have to pay taxes on it, and the demand for city services will be even less in those undeveloped areas of the municipality. You might well adopt policies designed to discourage school-age children in your jurisdiction. It's not that you don't like kids, they're great, you just want them to live somewhere else because they are expensive to educate. And so your preferred family types for those living in the borders of your town are one income, no kids, or double income, no kids. You might find yourself leaning towards discouraging low-income residents within your municipality. If the goal is reducing property tax burden as much as possible, well, you might take the view that lower-income families tend to pay less in property taxes because their land is less valuable and tend to consume a higher proportion, perhaps, of certain public services. And so that might give you reason to want to favor middle class or upper class residents within your jurisdiction. And to that end, you might encourage low density residential use of the property. So to the extent that you have residential areas, you might want to restrict them to single family homes rather than apartments or multifamily dwellings. You might require large lot sizes so that the houses will be spaced further apart. The lots will be more expensive and will make fewer demands on sewers and roads and other city services. This was effectively the strategy being followed in the Mount Laurel Township in New Jersey, the case that the authors have given us to look at in this portion of the textbook. So let me pull that up on page 602. About 30%, almost 30% of the land in the township was zoned for industrial use. This was probably significantly more than was going to be needed for actual industrial use, but this wasn't like the Village of Euclid zoning scheme. Remember, in Village of Euclid, if you had property zoned for industrial use, you could do anything there, including build residences. Here, the property that was zoned for industrial use couldn't be used for residential purposes. In Mount Laurel, shortly before the case, all of the residential land was zoned for single family dwellings. There had been no areas permitting townhouses or apartments except on farms for agricultural workers or mobile homes. There were different standards in different areas, but there were minimum lot size and minimum square footage requirements that essentially made it impossible to construct low income or moderate income housing. Now, recently, the township had branched out a little bit and began entering into what were called planned unit development contracts with developers. These allowed developers in certain kind of well-negotiated instances to build apartments or townhouses, but these were not aimed at low or moderate income tenants. The city made sure of that by the restrictions they put in the contracts with the developers. So the developers were required to offer amenities like central air conditioning. They had to contribute to various exactions for city services like fire, ambulance, education, culture, library, etc. And the result was that high rents were essentially guaranteed. There were sharp limits on the number of the apartments that could have more than one bedroom, and the developer was required to provide in its leases that no school-age children could reside in a one-bedroom apartment. And that in a two-bedroom apartment, no more than 2 children could reside there. The developer also had to agree that if more than 0.3 children per multifamily unit attended the public schools, the developer would come forward and pay for extra tuition and school expenses. The city had allowed development of a retirement community within the borders of the jurisdiction. But this was also a retirement community that was designed to kind of limit school-age population. No dwelling unit could have more than 3 occupants. Only one of them could be a child, and the child had to be over 18 years old. There was one experiment where the city or the township had approved what they called, quote, moderate income housing, but they required all of the housing in that area to be single family dwellings on 20,000 square foot lots, so almost half-acre lots, which kind of guarantees that you're not going to have low income housing in that area. All right, so the Supreme Court of New Jersey addresses this situation in the first Mount Laurel case. The holding of the case is over on page 607. Notice they are deciding this case under the New Jersey Constitution. Basically, if they resolve an issue under the state constitution, you don't have a basis for appealing it to the United States Supreme Court. And so the New Jersey Supreme Court kind of probably gets the last word on the meaning of the New Jersey Constitution. But here is the basic holding of the case over on page 607. We conclude that every municipality must, by its land use regulations, presumptively make realistically possible an appropriate variety and choice of housing. More specifically, presumptively, it cannot foreclose the opportunity of the classes of people mentioned for low and moderate income housing, and in its regulations must affirmatively afford that opportunity, at least to the extent of the municipality's fair share of the present and prospective regional need therefore. The legal ground or the legal basis for the holding is down at the bottom of 607, spilling onto the next page. Remember that zoning had been upheld in the Euclid case as an exercise of the police power, which is the state's general power to adopt reasonable regulations to protect public health, safety, welfare, or morals. And here, the court decides that the township had not exercised its zoning authority to further the general welfare. They say it is plain beyond dispute that proper provision for adequate housing of all categories of people is certainly an absolute essential in promotion of the general welfare required in all local land use regulation. Further, the universal and constant need for such housing is so important, and of such broad public interest that the general welfare, which developing municipalities like Mount Laurel must consider, extends beyond their boundaries and cannot be parochially confined to the claimed goods of the particular municipality. So notice something kind of unusual about this decision with regard to this concept of the general welfare and how it gets defined and applied. First of all, the court views the question of general welfare not from the perspective of the particular municipality that is making the decision, but they say you have to take into account interests outside your own borders. You have to think about the entire region in deciding what the general welfare requires. And then I think there's also a distinction from some of the other cases that we've seen with respect to where the power to define the general welfare lies. In other cases, courts have generally been deferential to legislative bodies in defining the general welfare. The legislature, as the people's representatives, were the ones who got to decide in the first instance what the general welfare required, whether it required single-family residences, large lot sizes, etc. In this case, the court has stepped in and essentially has told the legislature what goals they must seek to accomplish. So it has defined the meaning of the general welfare and said that, at least to some extent, the legislature cannot reject our understanding, our definition of what the general welfare requires. So we get down to questions of remedy over on page 610. And in the remedial section, basically, the approach is to tell the township to go and fix the problem. They say the township is granted 90 days from the date hereof, or such additional time as the trial court may find it reasonable and necessary to allow, to adopt amendments to correct the deficiencies herein specified. It is the local function and responsibility, in the first instance at least, rather than the courts, to decide on the details of the same within the guidelines we have laid down. Now, after the case, the notes tell us that there was a Mount Laurel 2 decision. The impetus for that case was the court's conclusion that municipalities had not been responding in good faith to their ruling in the first Mount Laurel case. And so the court expanded the obligations that it required of municipalities. It said that all municipalities are subject to these obligations of providing for a fair share of low and moderate income housing, not just developing municipalities. And it changed from an approach of deregulation, letting the market operate to supply low-income housing, to instead mandating affirmative government action to promote low-income housing. And so all of the cases that were decided under Mount Laurel 2 were going to be referred to a set of 3 judges who would decide issues of what was the fair share of each municipality. It's interesting, you could almost view it as the New Jersey Supreme Court kind of setting up its own administrative agency to deal with issues of housing. 3 judges are appointed to run the agency, and all of the cases are funneled to them so that they can kind of develop a uniform approach, a set of kind of working principles that they will apply to municipalities throughout the state. One of the mechanisms that was designed to enforce Mount Laurel 2 was called a builder's remedy. And basically how that worked is if a municipality refused to permit low-income development, the court could grant permission to a builder to do the lower moderate income housing project even over the objection of the local municipality. The outcome of the Mount Laurel experiment was that eventually the New Jersey legislature stepped in and adopted legislation to regulate in this area, kind of adopting its own administrative agency and its rules for how the burden of providing low and moderate income housing would be shared among different parts of the state. So one question that we can ask coming out of this opinion is, well, is exclusionary zoning an issue that ought to be addressed. There is some commentary that argues that maybe it's a good thing if municipalities can specialize in servicing the desires of particular segments of the housing market. And so maybe it's good to have certain municipalities that focus on providing for the needs of retirees, and other municipalities that focus on providing great schools for school children, and others like this one that focus on providing services at lower cost to middle income. And then you kind of let the market produce different kinds of housing options, and people make their choices from there. That's at least an argument that you see occasionally made in the literature. But let's assume that exclusionary zoning is an issue that we think ought to be addressed, that we think that it is not appropriate for a jurisdiction to try to exclude low-income or moderate-income property from its borders, that it ought to step up and provide its fair share of housing for all classes and categories of people. If we assume that's an issue that should be addressed, it still leaves the question of what's the best institution to address it. Should this be something that courts deal with, or should it be something that legislatures should step in and resolve? And so this kind of takes us back to a debate that has come up a number of times in different contexts in our property course about what are the relative competencies of legislatures and of courts. Remember, in the Boomer case dealing with nuisance, you saw the courts saying, well, basically, we're here to resolve disputes between neighboring landowners about whether a particular use is a nuisance to its neighbors, but we're not here to try and address large social problems like the problem of air pollution. We just aren't well equipped to deal with something that is so pervasive, has so many causes, affects so many people. That's something a legislature ought to deal with. So what about low-income housing? Is this like pollution? Is this a problem that is widespread with diffuse effects, that has complex causes, that arguably courts aren't ideally positioned to address, and therefore it should be left up to legislative bodies? I think the flip side of the argument here is, well, even if that's the case, the legislature in New Jersey wasn't doing anything. That in this case, it took the court's action, stepping forward and saying, this is something required by our state constitution, before the legislature got up and decided to enact legislation to deal with the issue. And so just another data point for our ongoing discussion of what are the appropriate roles of courts and legislatures. That is the end of our discussion of Chapter 11 on zoning.